Hello, my name is Jordan Steward. I am doing the Competence to Testify Legality and Considerations PowerPoint for Advanced Forensic Psychology for Arizona State University. I want to give you a quick introduction about myself. Hello, good evening. My name is Jordan Stewart. I'm from Chicago, Illinois. Today I'll be talking about competence to testify in court. This is an important concept, very essential because before any witness takes the stand, the court must decide if they're legally allowed to give testimony. The rules make sure testimony is reliable and fair, protecting both the witness and the legal process. But before I dive into the intricate project and topic, I just wanted to explain, why I gravitated towards an exceptional profession such as forensic psychology to begin with. So, forensic psychology is so appealing to me due to requiring an accurate analysis of complex situations, understanding psychological science and the law, and weighing evidence. It is more so focused on trying to understand every aspect of human behavior from a scientific and therapeutic perspective. Now, I know all of us in here have seen Criminal Minds, but I'm in it for more than just the action, even though that's not accurate at all. Anyway, different topic for a different day. So let's get into the introduction of competence. So competence is essentially the ability of a person to give testimony. You know, Competent witnesses must be able to give evidence in a reliable and truthful manner. The witnesses must be able to have the capacity to observe, recollect, and communicate. So that all of those are three essential concepts which are needed when discussing the concept that's interesting as testimony and competent and being competent to do so. So the courts presume everyone is competent off bat. So unless strong information is provided, which suggests otherwise, you're competent. It is essential to understand the concept of competence and how that differs from that of credibility. So competence is whether or not someone can testify, while credibility is how believable the testimony is. Competence is ultimately the judge's decision, while credibility is for the jury. So it's important to always remember that. And that is out of the federal rules of evidence for the rules 601 through 603. So let's get into the legal standards. Federal Rules of Evidence 601 through 603. So the main rules on competence are in the Federal Rules of Evidence. So 601 is stating how every person is competent to testify unless the rules say otherwise. So until say otherwise, you're competent enough to. So Rule 602 requires personal knowledge. A witness must have actually seen, heard, or experienced what they are testifying about firsthand, secondhand, but mainly firsthand. Rule 603 says the witness must take an oath or affirmation to testify truthfully. You know, these rules make the bar for competence very broad. Almost anyone can testify if they meet the basics. So if you meet the basics, you can testify. If you meet them, you can testify. So, and that's according to the Cornell Law School Legal Information Institute, Federal Rules of Evidence, retrieved from, the Law Cornell University. So, the key factors of competence. When a judge evaluates competence, they usually look at four things, four essential things. This is very important. Perception. Could the witness accurately observe the events? Are they able to accurately analyze and assess what's going on? Memory. Can they remember what happened accurately, days, weeks, months ahead, or prior to? Communication. Can they explain their knowledge clearly? Do they have the ability to? You know, the moral responsibility and ethicality. This is where this story gets really interesting, in my opinion. Do they understand the duty to tell the truth? Do they understand the ethicality, the essentiality to tell the truth? Do they? If someone fails one of these, for example, if they can distinguish between truth and lies, the judge may find them incompetent, and that's when, a lot of trouble commences. Special categories. So some groups raise special concerns. Children, courts don't exclude the kids automatically. Instead, judges test whether the child understands truth versus lies and can describe events. Now, let's be honest. A lot of children can't decipher truth and lies, but if they can, they will be deemed competent. Mentally impaired witnesses. Mental illness doesn't automatically disqualify someone. As long as they can perceive, remember, communicate, and promise truth, they can testify. So If the person has, about borderline personality disorder, bipolar disorder, they can testify as long as they can perceive, remember, and communicate and promise the truth, they are able to testify. And this is where it gets interesting, in my opinion. So experts, they must meet the basic standards of competence and have specialized qualifications to give opinions. So the system leans towards inclusion. They want to include everybody, every specific group, even vulnerable groups that can testify if they meet the basics. And that is according to Mueller, Kirkpatrick, of the federal evidence, and Walters Killor. Challenges to competence. My favorite. Lawyers can challenge a witness's competence. This usually happens before trial in a separate hearing. Some common challenges include the mental incapacity, such as severe mental illness, inability to communicate due to physical or cognitive limitations, not understanding the difference between truth and falsehood, which is more common than you think. If a judge rules a witness is incompetent, that person will not be able to testify whatsoever. And that is from the Evidentiary Foundations, the 10th edition. So, case law examples. Some examples show how courts apply these rules. Wheeler versus United States, which happened in 1990, no, 1895, the court allowed a child to testify because the child understood the difference between truth and lies. So, of course, they're going to let the child testify. The United States versus Lively. Even though the witness had mental illness, the court said he was competent because he could recall events and communicate truthfully. So this dials back to what we just said about the specialized groups, honestly. So the state versus Allen, 1994. That's disability and witness competence. And Kentucky versus Spencer, which is competency hearings for children. So these cases show the court's tendency to allow testimony unless there is a clear reason not to. Unless there's a clear reason not to, they're going to allow it. Practical implications. So in practice, judges decide competence before a witness takes the stand. Lawyers may challenge competence, but it's a high bar to exclude testimony. Jurors still hear most witnesses and decide if they're believable. So the essential takeaway is that competence is just the starting gate. Once a witness is allowed to testify, the jury decides how much weight to give their words. And that's from the Handbook of Federal Evidence, the ninth edition, Thompson Reuters. So attached below is an interesting case study video. So we're gonna watch how, or you all are gonna watch how the court evaluates witness competence when there are questions about age, mental status, and understanding. Notice which factors are emphasized, such as memory, perception, communication, moral responsibility, which is all are great subjects. Observe how the video shows application of legal standards in a real life scenario. In a real world scenario, please just observe how the video shows its application. So just to give you a little description of the video before you watch it, it explores how the court assesses whether a witness is competent to testify. It emphasizes that competence must be evaluated on a case-by-case basis, not by applying broad or fixed criteria. And key factors discussed include the witness's ability to understand questions, perceive what they testify about, communicate, and the ability to understand their obligation to tell the truth. The video serves as a case scenario style example applying legal standards in a realistic setting and how courts struggle with unclear situations and how legal rules guide the decision. And attached below is the video, so please feel free to watch it. So, let's get to the conclusion. To conclude, competence to testify is a threshold requirement. The legal system starts with the presumption that everyone can testify, right? Only if someone truly can't perceive or understand, they can't remember, communicate, or tell the truth, will they be excluded. So if they can't remember, perceive, or communicate, or even fathom to tell the truth, they will be excluded. This standard helps protect fairness in court and ensures that the jury has access to as much information as possible, which is very essential when discussing the court settings. And this is according to the Federal Rules of Evidence, Rule 601 through 603, which was at the beginning of the said presentation. I do believe that in today's day and age, it is essential to get as much peace, as much of the truth as you can, because it is so easy to get fabricated. We have stuff like ChatGPT, AI. It is essential to get as much of the truth as you can. So with that being said, these are my references, and I hope you have a great day. I hope you have a fan. I hope you got a fantastic time listening, and I can't wait to look at you all's presentation.